Welcome to the session on intellectual property rights and introduction. So, first of all we will discuss the terminology, basic terminology associated with intellectual property rights. Intellectual property rights is a combination of three words: intellect, property and rights. So, first let us have a meaning of intellect. It refers to the power of the mind, that is idea or a creation of the mind. Property, it refers generally to something that can be traded, that is that can be bought or sold, or in other words we can say that which has a commercial value. So, when we combine these two words, we have intellectual property or intellect property, which refers to the ideas and creations of the mind having commercial value. We may have different set of ideas that maybe are doing the same thing in a new way, that confirms to be the creativity of a person, but it will classify to be our intellectual property only if and only it has a commercial value associated with it. So, intellectual property refers to the ideas and creation of the mind having commercial value. When we add the third word to it, it becomes intellectual property rights. Just as we have fundamental rights, right to information, right to education, in the same way we have intellectual property rights. IPRs refers to the legal rights associated with intellectual property. The rights granted by the law to the I would say holder, owner of the intellectual property is known as the intellectual property rights. Why IP and IPRs are needed? First one is to provide recognition and reward for original effort, and second is to provide for protection of original effort and preventing its misuse through legal mechanism. For example, a person may come up with a, let us say a design of a or I would say a plier that can be used in automobile repair and maintenance, and at the same time it can be used in kitchen. In the same way, if that proposition or I would say that invention can be converted into a product form and it can be sold into the market, and the money can be earned by selling that product. So, it means that in case I am working on that product, another person may be from my colleague or maybe from some other part of the world might also be thinking on the same lines and coming out with the same kind of product. So, in that case who is the actual owner of that product? Who will own the ownership of that product is the subject matter of, I would say, IP, intellectual property. So, it is important all these rights are in that case, in the case of a plier, if it is a invention, it means patent is it will qualify to be filed as a patent, and for patent it has to be filed and owned by a person. So, the owner has the rights to sell it, to trade it, to launch that kind of product into the market, or to assign the license through exclusive or non-exclusive means or mechanisms. And second, the need for IPR is to provide protection of original effort and preventing its misuse through legal mechanism. For example, an inventor may come up with an invention to solve a particular kind of problem that he or she has in his or her mind, but if he or she does not have a ownership on that, then he or she may not be able to exercise his or her control over the utilization of that invention. For example, you may come up someone may come up with self learning material in context of, say, making teaching learning process innovative. In that case, if he or she does not have the intellectual property, anybody from the public domain can utilize it according to his or her use, that may not be right in a sense. For example, in case of a teaching learning mechanism, you come up with certain teaching learning mechanism that are to be used for say class 4th to 6th standard, but these are being I would say deployed for educational purposes in class 6th to 12th or 8th to 12th or 10th to 12th, but actually they may be meant for 4th to 6th standard. So, if you have the right over those kind of your creations of the mind having commercial value, then you can decide upon the right kind of utilization of your inventions. That is it. So, there are certain features that characterizes a property. There are certain parameters on which intellectual property and conventional or physical property are similar. So, the parameters on which they are similar are first monetary or commercial value. Let us have, we have a land or we own a car, it has a commercial value. We pay money to buy that car, to buy that patch of land. In the same way, your in case of someone wish to own your idea, he has to pay you in the form agreeable to both the parties. So, it has a monetary or commercial value. Second, documentation. Such as in the case of land, we have to get the registration of land done, and in the same way for vehicle, after purchasing a vehicle, we have to get the registry of the vehicle done. In the same way, certain documentation is associated in context of intellectual property also. There is a government issuing agency that is legally authorized, that is there. That is there in both conventional and physical property also, and in the same way in intellectual property also. Property description is there, ownership of the name of the owner is there, time duration of the ownership is there, and in the same way certain fees associated with the filing of intellectual property, just as in the case of conventional or physical property. There are certain parameters on which intellectual property and conventional or physical property are different from each other. First attribute is types. Intellectual property can be categorized into 8 well defined forms of intellectual property, or I would say as per Indian system 7 forms that are presently enforceable in India. Physical property, it may have different types exceeding 8. Valuation, second parameter is valuation. In case of intellectual property, it is not easy. Because it is not easy to judge the estimated value of the intellectual property. It may range from lakhs to crores to billions, I would say. And in the same in case of physical property, it is comparatively easy depending upon the geographical condition, location and the area in which it is being traded off. Theft, third parameter is theft. In case of intellectual property, it is not at all difficult. For example, one person is while in his or her interaction with another person, that idea may be out and stolen by taken forward by any other person. In case of physical property, it is not easy. The effect of fourth parameter is the effect of time on value. In case of intellectual property, it usually decreases and in many cases ends with time. But in case of physical property, it increases or decreases according to the type of property. For example, the basic fundamental principle is the resources on which the dependency of the human population will increase, the value of those resources will increase, and this is a supply demand concept, where the supply is more, demand is less, the value of those physical property will decrease. That is it. There are different types or mechanisms for protection of IP. There are the 7 mechanisms that are enforceable in India are patents, copyrights, trademarks, designs, semiconductor integrated circuits layout design, geographical indications, protection of plant varieties and farmer rights. So, briefly we will cover the definition of each. A patent is first patents. A patent is a right that is granted by the law for an invention. Invention is new product or process involving an inventive step and capable of industrial application. Second, copyrights. Copyrights refers to the rights granted by the law to the originators, creators of the original literary, dramatic, musical and artistic works, cinematograph films and sound recording. Trademarks. Trademark means a mark which is capable of being represented graphically and distinguishing the goods and services of one person from those of others. Designs. Designs means only the feature of shape, configuration, pattern, ornament or composition of lines or colors applied to any article, whether in 2-dimensional or 3-dimensional or in both forms. Semiconductor integrated circuits layout design. Layout design refers to layout of transistors and other circuitry elements and includes lead wires connecting such elements and expressed in any manner in a semiconductor integrated circuit. Geographical indication. Next one is geographical indication. Geographical indication in relation to goods is defined as an indication which identifies goods as originating or manufactured in that territory of country or a region or locality in that territory, where a given quality, reputation or other characteristics of such goods is essentially attributable to its geographical origin, and in case where such goods are manufactured goods, one of the manufactured goods, one of the activities of either the production or processing or preparation of the goods concerned takes place in such territory, region or locality as the case may be. Last but not the least, protection of plant varieties and farmers' right, plant breeders' rights. It refers to the rights granted by the law to farmers, plant breeders, with an implicit objective to encourage the development of new plant varieties, new varieties of the plants. Disclaimer, we acknowledge the work of various authors, organizations and institutions available from various secondary sources. Further, it is advised to refer to the learning resources listed in the e-content for this session for a more comprehensive understanding of the theme covered in this presentation. Thank you. Thank you.